This is the plaintiff, Constantine. He says the defendants are his neighbors, and they share a 72-foot-long, 6-foot-high fence between their properties. Unfortunately, the fence blew down. They agreed to split the costs, and then at the last minute, when the fence guy was ready to start the job, they canceled. He had to pay the entire cost of the fence, and is now suing his backtracking neighbors for the $1,550 they owe him. These are the defendants, Patricia and Terrence. Patricia says they never agreed to the plaintiff's terms or to the contractor for the job because they wanted a detailed proposal and never got one. Turns out, the guy he used was just a handyman. He didn't use redwood and he left a gap at the base of the fence. Now he wants them to pay for half of this shoddy job? No way. They're accused of refusing to be fenced in.
All parties, please raise your right hand. The People's Court is now in session. The Honorable Judge Marilyn Leal is now presiding. Litigants have been sworn, Your Honor.
Thank you, Douglas.
You're welcome, ma'am.
Okay. Mr. Constantine, you and Mr. Terrence and Ms. Patricia share a fence, correct?
Correct.
And at sometime in 2016, a 25-foot portion of the fence blows down, and everybody agrees that they're going to repair it. And what ends up happening?
Estimates go back and forth, really between the contractor that we agreed to go forward with, and the defendants. They kept asking for revisions to the proposal. They asked for revision after revision over a period of several months. During that time, I ended up moving out of the house with my family and ended up having some tenants that were going to move in. So I gave notice to the defendants that we've got some tenants that are going to be moving in. We really need to make a final decision.
And let's talk about what the revisions were. Tell me about it. What kinds of things were they asking for to be revised?
So originally, when the fence fell over, we had agreed on a standard fence and just replace it as is. Then after that, the defendants explained they wanted a slightly sturdier fence. They wouldn't have to revisit this issue in the future. And I agreed to that. So that was one revision. Another revision that they wanted were a different style of fence. They requested things like the cost of all of the materials for the estimate. So they wanted a more detailed estimate. That was the reoccurring theme that happened.
So what do you think was the last straw on that particular company? You had them ready to go, and like the next day, and these folks said, no, we still got more things we want to revise. We're almost there. And what happened?
The fence was ready to go, and the contractor was ready, but the defendants wanted more details, like they wanted the cost of nails, price of boards, and everything on the fence.
So what ends up happening with that contractor?
He came back and spoke with the defendants directly at least one more time, and gave another at least one or two more revisions after that.
And then he got sick of it.
Kind of the final straw for that contractor was the defendants got a separate contractor to come in and got a quote from I believe it was their friend to do work on the fence. And at that point, the contractor that we'd selected and we've been working with for several months said, this isn't the job for me, and withdrew.
Okay. And so now it's time to find a different contractor. So what happens? They said, you said that they had their contractor who they liked. What was wrong with him? Why didn't everybody end up going with him?
Well, I said that's fine. I'm happy to go with this guy. I just want to get a proposal from him. And on top of that, I found out that he wasn't licensed. And so at that point, I said, I can't go with this guy.
So you end up, at this point, you're totally in a crunch. You have tenants coming in. You don't want to have construction while your tenants are there. That's not part of the deal. That's going to cost you to lose money because the tenants aren't going to put up with that. But in any event, what ends up happening is you decide, I'm just going to go out. I'm going to hire them because California has a law that talks about shared fences and talks about it being shared responsibility. You happen to be a lawyer, so why don't you educate us on that?
Well, that's right. California has a law called the Good Neighbor Law. It's California Civil Code 841. You can look it up, and it says that neighbors are required to share fence costs. And I had mentioned this to the defendants in the past, and everyone had agreed that we were going to share the cost of this fence.
So let me
This
talk
wasn't
to
new.
you guys, Mr. Terrence and Ms. Patricia. What went so wrong that you decided not to pay him his half? He ends up hiring somebody. So you tell me your version of this. Why is it that it would not be fair under the California statute to say, hey, the fence benefits both of you, it's on your property line. He wants you to pay him your half. He paid for the whole thing, he wants you to pay him your half. You tell me why that's not reasonable.
What we agreed upon and what was built ended up being two different things. We got estimates. We submitted 2 estimates in 2017, and we did not get a
How much were the
response.
estimates?
I want to say there were 3,800, something like that. It was for Conhart redwood, which is a high-grade redwood.
Just basically high quality materials. So we want this fence to last for over 10 years.
Okay, I've read the text back and forth and the emails back and forth, and you guys seemed really persnickety, which is you're right, it's your property. But it doesn't matter what was revised, then you came up with more things to revise. Why was that? Why couldn't you all just come to terms with the contractor everybody had been happy with and get the job done already? What was the problem?
All we were asking for was just everything itemized, but he never itemized it. That's the only, sticking point. And everything.
Yeah, but you asked for that after the 3rd revision. You didn't ask for that from the beginning. You asked for that after the guy had invested all this time. In any event, you end up putting it up because you had, as you had warned several times, you had tenants coming in. When you put it up, the quote is 3,100. It ends up being a little more than that. And then you folks have paid 0. Not I don't want to pay half, it's I don't want to pay a penny. Tell me why you think it's appropriate that you not have to pay a penny. Because the law also allows a judge, in the absence of an agreement, to take certain factors into consideration and then to decide, should they pay half, should they pay a quarter, should they pay 0. So you tell me, persuade me why it is that you should not have to pay half.
Well, we were on board with the agreed upon contractor. On the night of the 27th, we got a text that he had conflicted out.
Yeah, let me tell you what happened in case you don't understand what that means. He got sick of you guys. I'm going to speak to you in plain language. He got sick of you guys and your demands. He doesn't want to tell you how much he pays per nail. He says, this isn't the job for me. The problem is the plaintiff is super polite and he doesn't want to just come out and say that, like most of my litigants. But I'm going to tell you, that is exactly what happened. So it's not his fault that the agreed upon contractor didn't do the job because the agreed upon contractor had now done 4 or 5 revisions. We move on from that, and now tell me, what about this fence is unacceptable to you that you should not have to share 50% of the cost?
We agreed upon high-grade lumber. That's not what was used.
You wanted a certain type of redwood and a different type of redwood was used? Is that what you're saying?
Yes, there's different grades of lumber. So we requested a grade A lumber, which is a Conhart lumber. We were looking at building for longevity.
I got it. And what kind of lumber was used?
Low-grade lumber.
What kind of, okay, you're saying that, but can you tell me, all right, you tell me, Mr. Constantine, what kind of lumber was used? Show me the receipt.
They provided a proposal that had just redwood boards.
Just said redwood.
I don't know what grade it was.
No.
I just wanted a standard fence.
And do you have any evidence that it was a lower grade than you had agreed to? What evidence do you have that it was a low grade? Your eyeballs, like you just feel it's lower, or what evidence do you have that it's a low grade redwood instead of the high grade redwood you'd agreed to?
Because I reached out to a lumber company because I wanted to know what type of lumber it was.
Do you have any evidence that it is a low grade redwood?
No.
Okay. Now, in addition to that, what else was wrong with it? It wasn't board on board, which is what you wanted, right?
That's correct. We wanted to build
but it was
for
a
longevity.
fence that matched the rest of the fence. Correct, Mr. Constantine?
That's correct. So we had agreed on board, but it's significantly more expensive. So originally I had agreed, yes, I'll go with board on board if we can get the fence done.
Oh, I guess then we shouldn't have made them angry. Okay, so now here you are. You're going to have to shoulder the entire cost because they're not cooperating. So you end up just going with whatever else was around your house, and you are objecting to it, and I understand. It's not what you had agreed to. I get it. What else was wrong with it?
The biggest concern is about the concrete. Our properties are 100% in sand. So I was very clear that the concrete was to be mixed outside of the post hole. The reason being is that when water is poured in, the sand will soak up the water versus the product. So that in
You
turn
know a lot
becomes
about
a
this
safety.
stuff. You should have just found somebody that he agreed to. He wanted to do the fence. How do you know, by the way, that this contractor didn't mix it outside?
I submitted photographs that showed the laborers with the bag of Sackcrete concrete being shook into the hole and then holding a 5-gallon white bucket full of water and pouring it into the hole.
Okay, there's a million pictures. Can you? Oh, here we go.
There we go. The last three.
Yeah, you are doing that. Well, you get what you paid for, right? So here we are, and now here's what I am left with. Oh, by the way, I won't want to cut you off. Is there any other objection that you have?
Welcome back to the People's Court. I'm Harvey Levin. The plaintiff is suing the defendants for half the cost of a common fence that blew down. The defendants wanted to use high-quality redwood. The plaintiff says, no way. Let's go back into the courtroom.
We agreed to a 6-foot completion of a fence. There was a tree in the backyard, and the fence was built over the tree, which added to the height. So the finished height of the fence is 15 inches above code.
Have you let code enforcement know that?
We have a shared fence. I have not.
Anything else?
There is an unusual gap in the middle of the fence where it goes from smooth on 50% of it and rough on the other 50%. The concern is that somebody could potentially get caught in this unusual gap in the top of the fence.
Okay. Why did they do this? Do you see this picture, Mr. Constantine?
I do.
What happened there? Why is the reason they did it?
I try to make it as fair as possible to have half the fence face my yard and half the fence face my neighbor's yard. They're identical fences. It's just the cross members are on one side for half the fence, on the other side for the half the fence. So it's essentially an identical fence.
But does that end up creating a gap in the fence?
It does create a small gap that's the width of a 2x4.
And that's a pretty big gap. I just don't understand. I mean, I guess you're saying you wanted it to be fair, half and half, but to me it looks worse that way, and apparently to them it looks worse that way too. All right, guys. This is one of those instances where California law makes sense to me, which often isn't the case. But they're very reasonable. They say, look, we want the parties to agree on a shared fence, but if they don't, and one party decides to do it, they have to do certain things. And if they do, then they get to talk, they get to ask a court of law to say, okay, you have to share in the expense. In this case, I have parties that are all completely on notice of the desire to do a fence, what kind of fence, everybody's working towards it, and in 7 stinking months, it doesn't get done. And he got sick of waiting, so he went ahead and did it. I am going to take into consideration that when he went ahead and did it, he didn't do board on board. I don't think you have proof that they used an inferior redwood. You got zero proof of that. According to you, he did it too high. I don't know if he did or not. According to you, they mixed it wrong, and I think you're probably right on that. I am looking at, your issues that I know because I see the texts, I see the emails, I see your demands. Some of your demands are reasonable, and some of your demands maybe just really aren't. It doesn't end up being what you had agreed to, which is board on board, but it is redwood, and it is a fence. And the suggestion that you should pay zero is ludicrous, okay? Now, what California law says a court should consider when they're deciding how to apportion the cost of the fence and whether it's fair to ask someone to pay half is whether it's a terrible financial burden for you. I find that it isn't. Whether the cost of the fence would exceed the difference in value of the property for you. In other words, did he go out and get a $12,000 gilded fence that doesn't add that much to your property? I don't think that's the case here. Whether the fence is more valuable to him than it is to you. And I think you got something there in your complaints about, well, why, maybe he doesn't care, but maybe you have a pet or you want a pet, or now all of a sudden, it's a problem if it's a tiny, tiny pet. The reasonableness of the particular construction or maintenance project, you've got to complain on the concrete. I got to tell you, I come from a long line of construction, and lots of people will do it that way. I agree with you. I don't think it's the best practice because of exactly what you said. The water gets, that's not how you should do it. Whether it's just an unnecessary fence, Well, that's certainly not the case. You want a defense. And anything else that I feel like considering, okay? And I'll tell you what else I feel like considering. He was very patient. He tried. There were a million revisions on contracts. You know, the contractors kept doing them for you. You still weren't satisfied. It really kind of looked like you just didn't want to go forward with it. So he got frustrated and he ended up doing it. Those are all factors that I'm going to take into consideration. He's asking you for $1,550, and I'm going to order you to pay $1,033, which ends up being your third of the fence. That is my verdict. Good luck, folks. And of course, your court costs. Thank you.
So the plaintiff is finally going to get some money from the defendants. Let me talk to the defendants, Patricia and Terrence. You know, it's interesting. The judge referred to you. She thought you were persnickety. Just to double check, I looked it up. It means someone who is fussy about small details. That kind of hit the nail on the head with you guys. What do you think about her decision?
Well, I mean, it doesn't hurt to be persnickety, right? Everything wants to be detailed, but we do want something that's longevity. And I have a feeling we're going to be at this again in the next 5 years.
Well, you're going to have to give the plaintiff $1,000 at least, $1,033, I think it is. That's the judge's verdict. You're going to have to live with it. You okay with that?
Well, as she says we have to pay, we have to pay.
Yes, you do. All right. Thank you very much. Mr. Constantine, let me ask you, how do you feel? Finally, this has been a long battle for you, hasn't it?
Been looking for closure. This is closure.
And does this do it for you? You okay with that?
You know, all along, I haven't wanted to do anything to upset my neighbors. I had a good relationship with my neighbors in the past, and I hope we can put this behind us and move forward as good neighbors again.
Okay, very good. Well, congratulations. Thank you very much.
Thank you.
And with that, let's have another session now of After the Verdict. Here are the judges.
Wow, quite a bit of back and forth here over the construction of this fence. I mean, I'm watching the revisions back and forth, half a dozen revisions. They had proposals years ago for this, and it was a long road to get it done. I think probably in this neighborhood, you probably could have gotten a nuclear power plant permitted faster than it took these guys to get the fence squared away.
Yeah, it was.
Did you get that impression?
Yeah, it was quite a bit of time.
And certainly this Good Neighbors law, or Good Neighbor Act that they have in California that governs commonly shared fences like this is in a sense intended to act as a shield to protect one neighbor from kind of just being taken advantage of or bullied or overpowered by the other neighbor. But sometimes when you have a statute that can act as a shield, you can use it as a sword too at the other party by asking about things like, well, how many nails are they going to use?
I want to know the price he's paying per pound for nails.
Right.
It was one of the last requests. And it's funny because I'm sure there's a lot of people within the sound of our voice who are saying, what? He wants to put up a fence, I got to pay part of it?
Right.
And thinking it's nutty, but I actually kind of think it's a really good policy.
And I shouldn't be too hard on the defendants because, hey, they were just watching, they were trying to make sure they got a quality fence built at the end of the day.
They were moving at a glacial pace.
They sure were. I was trying to do the math in my head. I'm thinking maybe 2 6-penny nails on each post at the top and maybe wherever the rails are. I was trying to do the count in my head, and I got to a couple hundred.
The plaintiff was so polite, too. He conflicted out. You know, he was trying not to say, yeah, they made him crazy, you know, which is exactly what happened.
Well, hopefully going forward, these people get along.
It sounds like it. They all seem like nice people.
Yeah. But boy, Mr. Constantine had the patience. Constantine has the
really
patience
did.
of Job, doesn't
Yes, he does.
My
Yes,
goodness,
he does.
To get this thing done.
Especially for a lawyer.
Right?
Charlie from Chicago wants to know, if my kid catches COVID at school and brings it home and someone in the family gets sick, can I sue the school for our medical bills? Wow. You are asking a really good question that I think is on the minds of a lot of people right now. This is an untested area, so I can't give you a yes or no. If the school acted recklessly and knew that people had COVID and didn't take the necessary precautions, and there is no immunity that the school might have, you could have a case, but you're going to have to look at what is going on in your city, if it's a public school, if there's immunity, and what the school did if it constitutes negligence or recklessness. That will do it for this case. Let's go back into the courtroom. The litigants are right there.